Okay, I am calling this meeting to order at 10:14 a.m. We will get started with the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. All right, I'm going to start with a roll call of the board members. Member Anita Liskey.
Here.
Member Colleen Rotkus.
Here.
And Chair Michael Crowner is present. I will entertain a motion to open this hearing for consideration of case number 2025-TOEB3. Can I get a motion, please?
Make a motion to open the hearing.
A second?
I second that.
All right, quick roll call. Anita Liskey.
Here.
Yes, for the motion. Colleen Rotkus.
I'm sorry. Sorry, what was it?
Just approving opening the case. Yes.
I support.
And Chair Michael Crowner, yes. So I will first turn it over to our counsel, Ed Mullen, to begin these proceedings.
All right, so the first thing I'd like to do is just confirm the filings that have been filed and make sure that we have everything provided to the board. So on Friday, the Candidates Council filed a motion to dismiss the objector's petition. Is that correct?
Yes.
And on Monday of this week, the objector filed a brief that responded to the motion to dismiss and raised arguments in support of the objector's petition, and that was filed in the evening after 5 p.m. on Monday. Is that correct?
Correct.
On Tuesday, the Candidates Council filed a motion to strike the brief filed by objectors on the grounds that it was filed after 5 p.m. And that the brief in support of the objector's petition should have been filed on Friday. And also filed a reply responding to the brief filed by the objectors on Monday. Is that correct?
Yes.
And there are no other filings that have been filed. So that's complete. Okay. What I would like to do to begin the hearing is see if we can stipulate I don't think there's a lot of factual dispute, but I want to include in the decision the series of events that occurred. And I want to make sure.
So I prepared booklets for everyone with what I deem the pertinent documents. That if we can enter them into the record.
What do you mean by the pertinent documents?
To establish the timeline. So the certificate of nomination by caucus, the original, the January 21st resolution to fill the vacancy, the January 22nd electoral board order, the second objector's petition, February 14th electoral board order, and the February 17th resolution to fill vacancy.
Can I just compare that with what we got here?
I put a demonstrative exhibit. Everyone, I'll give it to opposing counsel to review also.
Do you have a copy?
I have copies for
Mr. Capper, do you, I'll share this with the board.
So we have two preliminary motions pending before we would even get to anything related to the underlying substantive.
I understand that. I just wanted to have the factual record established for the. But you have one for everyone
I
here.
do.
So what are you asking us to stipulate to? Because these are documents that don't appear to be certified or anything.
Nor were the documents you attached to your motion.
They weren't because the people didn't comply with FOIA requests on time.
Right, so I wanted to, you made a FOIA request for the certification, so I wanted to see if we could stipulate. Or take judicial notice of that, because you don't have certified copies, but they were,
Well, the reason I don't have certified copies is that there were never any amended certifications filed with the Will County Clerk's office. So there was only,
That's incorrect.
there's only the January 22nd original certification.
4 different certifications from Annette Parker.
okay. We'll put this as part of the argument. I thought we would be able to stipulate to this, but let's put it as part of the argument. The first motion that is pending is the motion to strike. So would you like to present your motion to strike?
Yes, so the motion, it's the motion to strike and dismiss the petitioner's memorandum of law in support of objector's petition in response to candidate's motion to dismiss. So when the board last met, they entered an order establishing deadlines for certain things. If we had any motions, we were to file them by 11:59 on Friday. If they had anything in support of their pleading, they were supposed to file that by 11:59 on Friday. We filed a motion to
Short
dismiss.
circuit this, I'll withdraw our filing. We'll argue it here.
I have
We'll
no,
argue it today.
I have no
I don't
objection.
need to rely on what was filed on Monday.
Okay, if they want to withdraw it, then they're withdrawing their memorandum in support of the objector's petition in response to the candidate's motion to
But-
dismiss.
Still preserving our ability to argue a motion to dismiss today and put on our case in chief.
What was the relief that you requested in your motion?
I wanted their pleading to, they were, on the first motion, their pleading to be stricken, their response pleading that was untimely filed.
Okay,
If they're agreeing to withdraw that.
okay, then the second motion.
All right, so then we have filed a motion to dismiss the underlying objector's petition. And basically, there's a couple reasons for that. First of all, is that, and have the board members been provided with copies of
Yes,
our pleadings? Okay. So the election code requires that when an objector's petition is filed, it must fully state the nature of the objections. Now, the objector's petition makes a lot of allegations, but it doesn't really tell us what the alleged violation is with the nomination papers. Now, the only way we learned of what the argument was that actually the objectors were making were by the late filed document that they've now withdrawn. Had they not filed this, we would not have known what their argument was at all. And here's the reason why. They go through kind of the history of the filings here and the different challenges that have occurred. And then what they state is that on February 17th, the party filed another resolution to fill the vacancy nomination, and this is what it alleges. The resolution falsely identifies the date of the event creating the vacancy as February 14th. To the contrary, the vacancy was created when the electoral board issued its final decision on January 22nd. Since January 22nd, there was an entire electoral board proceeding that occurred. There was deliberation on that, and there was a ruling that was issued on February 14th. That created another vacancy nomination. There is nothing in their objector's petition that says why they're completely disregarding the second electoral board proceeding or what their theory of the case is. So when we received the objector's petition, we were trying to figure out how to defend it, which is why you have to fully state the nature of the objections. And one of the things we thought is, well, okay, the electoral board issued a ruling on January 17th. And they signed the decision on the morning of January 22nd, but also on January 22nd, that's the day that the party filled the vacancy nomination. So I think what they're arguing is that the vacancy nomination was perhaps filled before the electoral board's decision was entered. So that's what we thought the basis of the objection was, because there's nothing in here explaining what the basis of their objection was. Well, when we received the now withdrawn memorandum of support, what they're actually arguing is, oh no, the electoral board's second ruling, taking the candidates off the ballot, didn't create a vacancy in nomination because of this other case. Now, they don't cite the case at all, and we have no notice at all from the objector's petition that that's what their argument's going to be. And in our response, in support of our motion to dismiss, we go through the cases where we say, hey, the appellate court has really analyzed the section 10-8 before. And what does it mean to sufficiently put somebody on notice? And the cases that I cited were about objectors' petitions where people said the petitions didn't file, the candidates didn't file enough signatures. So you would think if someone said, well, they didn't file enough signatures, that's putting someone on notice of what the argument is, right? The court said, in at least the two cases that I cited in here, no, that's not sufficient, because you can't just argue what the alleged flaw is. You have to fully describe the nature of the objections. And in those cases, they said, well, the candidate wasn't just saying that the objector wasn't just saying that the candidates didn't file sufficient signatures. They were saying the reason they didn't file sufficient signatures were because of these underlying laws that really have to be interpreted here. And this is what the appellate court stated in the first case, Jeffers' entire objection was composed of one meager sentence alleging that Katsinas submitted less than the minimum number of required signatures. As later evinced, Jeffers' theory of the case was based on an exacting analysis of the Ramirez decision, election cycles, and the township's voting history. Even under the most generous definition, we find that Jeffers' single sentence could hardly have been interpreted as having fully stated the nature of the objection to his nomination papers as required by section 10-8 of the election code. And in rendering that decision, what the appellate court said is that it does not provide essential information to the other side to actually defend the objections. So just putting in the objectors' petitions that there were not enough signatures was really not enough to let the candidate know, well, what are we arguing about? There was a second case also where it was called the Polanco versus Cook County Officers Electoral Board case. And it was another case where the court said, you have not sufficiently stated the nature of the objections here. And here, the court really held the same thing. The Polanco's theory of the case was entirely based on such a nuanced analysis of the election cycle and the township voting history. We cannot say that their bare bone objection compressed into a single oblique sentence provided anyone, whether the candidate, the board, or the public, with even the slightest scintilla of fair notice to the nature of the objections. So with that background, with respect to what the law is, we have to look at this. How would we know from looking at the objector's petition? And if they've withdrawn their memorandum, we technically wouldn't even know right now what they're arguing. The first time the candidate learned what the objector was arguing was not through the objector's petition, it was through the late filed memorandum of law. And here, what they are stating, they raised a couple of arguments, which I presume they will raise in support of their objector's petition if we get that far, but it's the case that they never cited. There's a case called Maskey that in one instance held where a candidate, a political party failed to meet a deadline for filing for the primary election. They filed too late to do that and they were thrown off the ballot. So then what the candidate cleverly said was, aha, we're going to say that the electoral board taking us off the ballot actually created this and we're going to fill that on time. So that allows us to bypass the first filing requirement. And the appellate court said, no, you can't bypass the first filing requirement when the primary is involved in that instance. So that's not what they're arguing. They're saying, well, wait a minute, the second electoral board ruling in this case, even though it wasn't at all related to a primary filing, is what created the vacancy in nomination. But we don't know that at all from the objector's petition. So they can't, under the board's own rules, under Rule 5, you don't allow objectors to amend their petition. And that's consistent with the Second District Appellate Court's ruling in the Reyes versus Bloomingdale Township Officers Electoral Board case, where you can't amend an objector's petition when it's filed. The second thing they argue is that, well, we sufficiently allege that the vacancy in office did not occur on February 14th. Well, while it is true that there's a sentence here saying that the resolution falsely identifies the date of event creating the vacancy as February 14th, they don't say why they believe that's false. So that's very similar to these cases with the page numbering, where the candidate had noticed that, well, or not the page numbering, with the insufficient petition signatures, where the candidate knew they were making some kind of argument about insufficient petition signatures, but they weren't fully stating the nature of the objections. So because the objector's petition does not fully state the nature of the objections, the petition should be dismissed.
Okay, so it appears she's foregoing her arguments to the substance of the objection.
We're not even at we're only at.
Well,
a
your
motion to
brief, your
dismiss.
motion to dismiss argued the substance also. Are you foregoing that?
No,
All right, so as it relates to the pleading, which is truly the only thing in the brief that's a motion, subject to a motion to dismiss, the other part of her motion to dismiss went to, it attached documents outside of the four corners of the objection, and it wasn't in the nature of a motion to dismiss. So dealing with the pleading issue, she's correct. Section 10-8 states that an objection shall state fully the nature of the objection. This has been interpreted to allow the candidate to prepare their defense. We clearly allege that the resolution filling the vacancy is in violation of section 7-61 because the resolution falsely identifies the date of the event creating the vacancy as February 14th. To the contrary, the vacancy was created when the electoral board issued its final decision on January 22nd, 2025. So that is sufficient information for them to prepare their defense. In fact, she's arguing her defense right now is that the February 14th action created a vacancy that we could fill. She's arguing her defense. All I have to allege is what statute was violated and why was it violated? It was violated, 7-61 was violated because the act that created the vacancy occurred on January 22nd. That's what I have to prove. I don't have to prove all of her potential defenses. Okay? I have to prove what I have to prove for my objection. My objection is 7-61 was violated because the vacancy occurred on January 22nd, 2025, and it wasn't filled in the time frame provided. That's all I have to prove. So this is unlike the cases she's citing about where there's a single, as she stated, single opaque sentence. There's much more than a single opaque sentence here. There's more than enough for her to prepare her defense. In fact, she's arguing her defense. She also argues in her reply that, well, this is the first time mask is being raised. There is no requirement to cite case law in an objection. And she hasn't cited a single case where an appellate court or otherwise has said, you have to list case law you're relying upon. No, you list the facts. And that's what we listed. We clearly complied with 10-8. There is no requirement that you have to think of every potential defense that the other side may raise, and we have to negative it in our pleading. It's never been a requirement. The cases she relied on where you say insufficient signatures, period. Well, right, you're supposed to identify which signatures are invalid and things of that nature. Here, we clearly laid out the facts that we need to prove to our case, that we're telling them that in our belief, and we're going to produce facts that support this, the vacancy occurred on January 22nd, not February 14th. Therefore, their attempt to fill the vacancy violated section 7-61 of the Illinois Election Code. Thank you.
In reply then to that, it's very interesting, one of the last statements they made, we are going to produce facts to support this. That's exactly what the problem is here. If there are facts to support their objection, this is a fact pleading state when it comes to what has to be specifically pled in an objector's petition. And there aren't any facts here that you can look at that say why they believe the February 14th vacancy did not occur. There's not one sentence at all that says that in here. And with respect to the reference to the signature cases, that's what the appellate court was saying. They were saying you have one sentence in your pleading saying that there's insufficient signatures. Why are you saying that? Here, when you read through all of their paragraphs, they have 16 paragraphs in their objector's petition. There's only one that claims the resolution falsely identifies the date of the event creating the vacancy as February 14th. That was the date the vacancy was created. They're not saying why it wasn't. They're saying, no, there was a vacancy created after the first electoral board decision on January 22nd. There's nothing in here at all explaining why they believed that was vacant, and that is not sufficient. And there are cases that describe what it means to fully state the nature of the objection. And while there's not one particularly on this issue, they still have to fully state the nature of the objection. And I just gave you one example when I presented my original argument as to what we thought the objection was. We thought, okay, they're saying that there was a vacancy on January 22nd due to the timing of the filing of the electoral board's decision and the resolution to fill the vacancy. We did not learn that. So whatever facts they're going to bring forth now, and interestingly, when they filed their motion, they included suddenly 4 pages of facts that should have been brought forth in their objector's petition. So that's not sufficient. It's not sufficient to put us on notice.
Final comment. If she's correct, when you have signature-based objections, and I say, and I identify a signature and say, this person is not located within the district. By her reasoning, I have to say, because they are in Plainfield Township, not Wheatland Township, for every signature. That's not the case. All you have to allege is the person is not registered in the applicable district. If someone has a felony, just state they have a felony and they're not qualified. We don't have to say, and the pardon that they received from the state of Michigan is invalid because of XYZ. You just have to say they have a conviction, they're not eligible, they falsely swore to their statement of candidacy. I don't have to go into that some pardon that they may have received from the governor of Michigan is valid or invalid and cite the case law. That's what a fact-finding hearing is for. It's a fact-finding hearing. I don't have to sit here and theorize and decide every potential defense that the other side may raise and have to plead out facts to disprove their potential defense. The objections would be books. That's not what's required. State fully the nature of the objection. You violated 7-61 because the event that created the vacancy was on January 22nd, not February 14th.
Mr.
We
Muller,
met the
can I get
requirements
some
of 10-.
clarification?
Yeah,
When?
what
Can I have a conversation with you about what I'm hearing?
they will finish their thing and then we'll,
Yeah, I need some guidance.
okay. It's your motion, so you can have the last word if you'd like.
Thank you. Well, I can tell from counsel's comments that he hasn't even read the cases I cited. Because in the cases I cited, while they challenged signature requirements, they didn't say it's not sufficient because they didn't put a village or a town. What they said, there's a lot of complicated calculations that are involved in determining election cases. Mr. Mullen and I represented appellate court justices fighting over Supreme Court races because they could not figure out how to calculate signature requirements. So while someone files a challenge like they did in the Jeffers case, they said the candidate doesn't have enough signatures. Well, why not? Well, based on the calculation after redistricting in this ward, in this precinct, and this law, and that's what's happening here. This is not a simple statement because the underlying argument that we learned from the memorandum of law is that, no, you have to look at the underlying case law regarding when a vacancy is created, and you need to analyze what that means, what it means to create an actual vacancy. There's nothing about that in the objector's petition at all. Nothing at all states that. So I'm not raising a hyper-technical defense here. I'm raising a fundamental due process argument that, hey, we have to defend why he should stay on the ballot. We have to defend why the party believes that it acted the right way. We don't know what we're arguing based on this. There was, when you look at the factual allegations in the memorandum of law, now there's 4 pages saying, well, this is why the second vacancy was not there, the second electoral board decision was not sufficient to create a vacancy in office. That's what needed to be in here, and it wasn't in here, and that's what the problem is. Thank you.
So do you have questions for
I do.
me or
I
for
wanna start
council? Okay,
On the, objector, Margaret Tyson's, the original objection. Where does the signature situation come in? What point?
there are no signature objections here. What Ms. Craftheffer is arguing is there's another appellate court case
Okay,
that talked about an objection where they were objecting to the number of signatures. And the appellate court said that the objection was
so that's just case
insufficient.
law.
It's a case law, yeah,
It does not, is not being brought up in this.
correct.
Okay. Why are they able to act like February 14th didn't happen?
So the question is, when they argue their case, they have to talk about February 14th because that happened. And the question is whether or not
Why
that
is it
was.
not acknowledged here?
Well, see, the question you have to answer here is whether they gave enough information in this objection for you to understand what they were arguing. They didn't have to cite case law. They didn't have to support but they had to give you enough information that you understood what the objection was, right? When they come in here, they give you the evidence, they give you the argument, they give you the case law, et cetera. But this had to give the candidate enough information to be able to defend the case. So you understand what the objection is. The objection is that whatever happened in February was not, they are saying that didn't count because it was improperly done, right? That's what they're saying. Do you understand that from reading paragraph 13 and 14 in particular that says the resolution falsely identifies the date of the event creating the vacancy as February 14, 2025. So what they're saying is that the resolution falsely identified February 14th as the date of the vacancy. And what you have to ask yourself is that enough information for you to understand that they're saying that whatever happened on February 14th was legally insufficient and that the vacancy on January 22nd was never filled? Is that enough for you to understand that? And for them to understand that and come up with a defense?
So I think for us, there's 2 things, right? So first, because we've gotten part of like arguments of case, but also part of arguments regarding the motion to dismiss. First, we're talking about motion to dismiss, right? Which is whether we as a board and whether they presented a case for why this hearing should even occur, essentially, right? And whether that was sufficient for us to understand. That's one of the whole like February 14th versus
January
22nd.
22nd.
That's the next piece that would come later, right? As far as them arguing which is the
So,
valid
right,
date.
so if you decide that this was alleged sufficiently in the objector's petition, then we move on and discuss whether or not the objector's petition has merit. Now, I'm gonna recommend that we do that anyway, because if we go to the appellate court, we
Right.
wanna have
Sure. Gotcha.
everything done and not have to come back here again and redo this.
Mhm.
But
Well,
that would be my
probably.
recommendation.
So we're clear then, this first vote on the motion to dismiss is not to determine the valid arguments of the objection, it's whether we're gonna basically continue forward with hearing arguments.
Right, but you could also not. No one could move for anything right now. We could go on to the merits and then you could do one joint motion at the end.
Okay, thank you.
And that, because I would recommend that we do that anyway, because
Do one.
we don't want to come back here.
Do it at the end, you're saying do one.
Two goals,
at the end.
is that what you're-
Yeah, do one motion at the end that resolves both of the
I think,
issues.
is that what happened in the
first
That's what we
hearing,
did in
where
the
there was
first.
like a roll call with a bunch of different motions?
Yes,
Okay,
second hearing,
second. hearing.
you're first.
The
So you're right,
February
it
14th.
Well,
was,
the
it was
first,
the
I
first
wasn't
one, you're
involved
right,
with the
it was the first one. Okay, okay,
I like what you're saying about holding it to the end.
okay. Would you like to move on to the second half of your motion to dismiss on the merits?
Well, it's on the merits, it's not a motion to dismiss.
Yeah, what do you mean?
You had a second half of your motion to dismiss, didn't you? Or no?
That well, it's that the resolution was in compliance, because at the time we filed this, we were still guessing what their argument was. So I think I can hold off on that argument until they make their case in chief on.
Okay,
And so then do we want to go back to these documents?
yes,
That's yours.
Well, before we do that, you had asked whether or not we wanted to stipulate the facts.
Well, that's what we're talking about.
Okay,
Can
then
we
that's not
stipulate-
related to the document. So what are the facts? Because you had a whole list of facts you wanted us to stipulate.
right, but the facts, this actually matches up with the facts. So the number one is that the candidate was nominated on December 3rd by the Republican Party at the Republican caucus.
Yes, we would agree with that fact.
Maybe,
That the candidate filed nomination papers and resolution on December 16th, 2024 to be a candidate for the Republican nominee for assessor in Wheatland Township,
what date? I'm sorry.
Hmm?
What date?
December 16th.
I'm sorry, can you repeat that they filed on December 16th, what? Their
They
nomination
filed the
papers?
certificate of nomination and
Yeah.
nomination papers to be a candidate for assessor on December 16th.
Okay. I don't know the date that they filed. Is that somehow key to the date that they filed? I don't know the date, so.
I don't think it's in the,
Okay, that on January 22nd. At 9 AM, the electoral board. Entered a decision removing the candidate from the ballot for failure to file. His assessor qualifications with his nomination papers.
Yes,
yes,
Okay, on January 22nd. After 9 AM. Candidate filed. A resolution to fill the vacancy and statement of candidacy. And the resolution says that he was nominated. On January 21st, 2025.
yes.
yes.
On January 29th, 2025. A second objection was filed against candidate. Alleging that. He failed to file his statement, his receipt for statement of economic interest. And that the resolution. Nominating him was invalid because
Paragraph 10.
the meeting nominating him occurred on January 21st, 2025.
But there was no authority.
Hmm?
We stated there was no authority to fill the vacancy. That's what the objection is.
Well, can we just stipulate that an objection was filed and then the document can speak for itself?
Okay, are you okay with, we have not entered that exhibit into the record in this case. Would you be okay entering that exhibit, that document into this case?
Which one is it? Is it four?
This is the resolution.
Exhibit 4. That's our the objection.
Yes, that's fine. Now, wait, so it's dated on the 27th, but you're saying that was filed on the 29th. I don't have information on what date that was filed.
You look, there's a stamp, January 20th, at the, right below first page, number 5. See January 20th? No. That's 29.
Wait, exhibit 5?
Exhibit 4, first page, there's a stamp that says January 29 for the date that the objection was filed.
Yeah, so it was signed on the 27th, but it wasn't filed until the 29th.
I don't see anything on mine.
It's very light.
Oh. Okay, all right, that's fine.
And on February 14th, 2025, the candidate was removed by the Electoral Board.
Yes,
Are we getting the, is there an objection to that order going into the record?
the electoral board 714 decision? No,
Can you put the first and second decision into the record
that's
of the
fine,
electoral board?
that's fine.
Is that date that the candidate was removed that you're going?
February 14th.
We all had that wonderful Valentine's Day together.
I can't think of a better way to spend Valentine's Day.
Okay, and on February 20th, 2025, candidate again filed nomination papers indicating that he was nominated to fill the vacancy created on February 14th at a meeting held on February 17th.
Yes, I agree with that.
Yes. And that will be in the record also. Right,
Yes. So, I'm going to take the objector's petition, which is exhibit 4, and mark that as board exhibit 8. And then I'm gonna take the decision and mark that as board exhibit 9. So other than the objection and the decision, was there any?
both decisions. We've agreed to enter both decisions into the record. The January 22nd decision and the February 14th decision.
Do you have any objection to that?
No.
Okay, so I'll mark the January decision as 9, or sorry, it's 8. Mark the objector's petition as 9. And I'll mark the February decision as 10. And I'll ask someone to make a motion to enter those into the record.
I'll move to enter all of that into the record as presented by Council Ed Mullen and agreed to by council for the objector and petition. I'm sorry, and candidate.
Second.
Roll call, Anita Linsky,
Yes.
Colleen Rockets,
Yes.
Michael Crowner, yes.
All right, we filed an objection asserting that the Republican Party of Wheatland Township violated section 7-61 when they nominated Mr. Bruce Dorada as the nominee for the office of assessor of Wheatland Township on February 17th of this year. We allege that they violated section 7-61 of the Illinois Election Code, and the pertinent section reads: any vacancy and nomination under the provisions of this Article 7. Now, you're a township, you operate under the township code, but section 10-11 of the Illinois Election Code says vacancies shall be filled pursuant to 7-61. So any vacancy and nomination occurring on or after the primary. So primary, as you know, the township is subject to the caucus, and the case of Lenhen v. Township Officers Electoral Board says the caucus is the equivalent of a primary. All right, so for purposes here, when it states on or after the primary, for your purposes, it's on or after the caucus, because case law holds that the caucus is the equivalent to the primary. And that makes sense, because if you read the next sentence, on or after the primary and prior to certification of candidates by the certifying board or officer. So the 7-61 provides the definition of what the certification means. It refers to the act of officially declaring the names of candidates entitled to be printed upon the official ballot at an election and directing election authorities to place the names of such candidates upon the official ballot. Certifying officers and boards refer to for our purposes, the local election official. So it's when the township clerk sends the ballot certification to the Will County clerk, all right, which statutorily was required to occur on or before January 23rd. All right, so let me read that sentence again. Any vacancy and nomination occurring on or after the primary and prior to certification of candidates by the certifying board or officer must be filled prior to the date of certification. Okay, so any vacancy and nomination occurring after the primary / caucus, but prior to the certification, January 23rd, any vacancy occurring in that period must occur prior to certification. All right, second sentence, any vacancy and nomination occurring after certification, in our case, after January 23rd, but prior to 15 days before the general election, shall be filled within 8 days after the event creating the vacancy. All right, so we just went over the record, our exhibits, and we know by the stipulations, Mr. Dorada was nominated on 12/3, which was the date of the caucus. That he filed on 12/16. And on 1/22, January 22nd at 9 a.m., he was removed from the ballot. The Republican Township, the Republican Party of Wheatland Township caused to be filed a resolution filling a vacancy, and they called the meeting on January 21st. Prior to Mr. Dorada being removed initially from the ballot. An objection was filed, and an objection was filed stating, in addition to other things, that the Republican Township of Wheatland did not have the authority fill the vacancy on 1/21 because no vacancy exists. Right, and that was paragraph 10 of the objector's petition to the January 21st filing. And we stated the resolution had no effect and was a nullity. Following that objection, there were hearings, and in counsel for Mr. Dorada at the time, who admittedly is no longer counsel here, called Mr. Mullen and stated that the petition has merit and they will not be contesting the objection. That was adopted. It was a statement by Mr. Dorada through his counsel. They're judicially stopped from arguing otherwise. Because there's a principle of law that you cannot collaterally attack final decision. And you can't, and you cannot argue one position in one proceeding and directly in the opposite of another proceeding. You're judicially stopped from. So they admitted that that objection was based on legal grounds. And that's a final order that was issued. Both electoral board opinions are final orders. So following the February 14th order where Mr. Dorada admitted all the allegations in the objector's petition that.
Objection to that. I don't think there's any evidence he admitted all the allegations in the objector's petition. The statement by counsel. The statement by
You
counsel.
have a chance to put on your case, all right? You're not, it's not an objection, you're arguing.
I'm objecting to your
Okay,
characterization.
counsel. Speak to the board. I understand your objection. You can raise that in your argument. There's a email, it was not a phone call, it was an email. That email is in, the language of that email is in the order that we just put into the record. So if you have any questions about what the order said or what the email said, you can refer to that later.
Paragraph 4 of that order states candidate Dorada's attorney acknowledged by email that the grounds, unqualified, that the grounds stated in objector's petition. They didn't say a single issue. They said the grounds, all inclusive. Stated in objector's petition have merit. And they will not be contesting the objection. That's what was stated by Mr. Dorada through his counsel. So following this February 14th order, the Republican Party of Wheatland Township again attempted to fill the vacancy now allegedly created by the February 14th order. We are here today because we said this is not how 7-61 reads, okay? The vacancy was created on January 22nd. 21st was a nullity. It was admitted by all parties to this action. It was a nullity as if it never happened. It was void from its inception. They now filed a second improper attempt to fill a vacancy. This violates 7-61 because under either sentence, any vacancy in nomination occurring on or after the primary and prior to certification, vacancy occurred on the 22nd prior to certification, must be filled prior to the date of certification. That clearly was not met by the Republican Party of Wheatland Township. Alternatively, any vacancy in nomination occurring after certification, but prior to 15 days before the general election, so any attempt after the 23rd, must be filled within 8 days after the event creating the vacancy. So the vacancy was created on the 8th, or they had until the 30th. Fill the vacancy.
January
3rd, sorry. So the 21st, admitted by all parties, was a nullity. There was no attempt to fill the vacancy. They now attempt on February 17th to fill the vacancy when it either had to be done prior to certification or alternatively by January 30th. So what I'm getting to here is I cite the Maskey case, 234 Illap 3rd, 508. And although not the exact language, it's been amended and it's different, it's admittedly different issues, but the principles apply. The appellate court said Maskey they attempted multiple times after the time frame to fill a vacancy, all right? And the court, and they said, well, you know, when you threw us off the first time, that resets the clock. And now we get to fill that vacancy from the first improper vacancy attempt. And the court said to accept Maskey's argument that he was able to fill a vacancy created when the board denied his first petition at any time prior to set certification would render the 60-day requirement of 7-61 a nullity. Now, the 60-day requirement's gone. This is a 1992 case. It's pre-statute, but the same principle applies. To accept Mr. Candidate Dorada's argument that they can just keep filling vacant illegally in violation of 7-61, they can fill it after the time frame, and the removal, the declaration by an electoral board that their attempt was done in violation of 7-61, they have no authority to do so. It renders the timeframes in 7-61 superfluous. What's the point? Why do I have to follow them? Because all I'll do is do it illegally. You'll throw me off, but then you know what? I get a new 8-day window. The Maskey court's saying, no, you have to give purpose to these timeframes. And if you interpret it a way where you can do something wrong the first time and reset the clock and build off of that, it renders the whole purpose of the statute meaningless. All court had held Maskey cannot attempt to circumvent the clear and unambiguous language and time limits set forth in 7-61 by filing successive nominating petitions under the same party which have been previously denied. That's what's going on here. They're trying to build off of a nullity to give them authority to fill a vacancy so they can reset the clock. But the clock ended. Give the statute purpose. The clock started running on January 22nd, 2025. All parties, Mr. Dorada included, have admitted that the January 21st nomination was a nullity. And that's why we believe that 7-61 was violated. The February 14th date appearing in the February 17th resolution to fill the vacancy is incorrect. And the vacancy occurred on January 20th. The true vacancy occurred on January 22nd, 2025. Similar to Maskey, they're trying to do something improper and build off of that to reset the clock. Maskey court prohibits that now, and that's why this should be declared invalid. Council is likely going to say, well, 7-61 talks about a primary. 7-61 has to be read in pari materia with the township code. The appellate court has said caucus is the equivalent of a primary election. The nomination candidates should be given the same level of credence as the results of a primary election. There is no certification to be done, certification of candidates that's referenced in 7-61 after the January 23rd date. So it's nonsensical to interpret primary as something in this purpose, in this issue, in this matter, as anything other than the caucus. That's what the appellate court tells you to do. That's what rules of statutory interpretation tell you to do. And the definition of certification and certifying officers or board refers to the clerk of the township, to the clerk of the county. That was done on January 23rd. For all those reasons, we believe that the objection should be upheld and the resolution filling the vacancy on February 14th or February 17th should be declared invalid.
Before you started, just a question, in 7-61, it says that the vacancy must be filled. What is your definition of the word filled? What does it mean to fill a vacancy?
To put an individual into the nomination for that office by the party.
Okay. Is there any statutory or case law that defines what that means?
It's the act, there is, it's a Blagojevich case, from 2009. It is the act. Marbury versus Madison. It is the act. It's when the person with the authority to appoint completes their action. It is when the party completes its action of voting. Nominating at the meeting.
Okay, so if no one had filed an objection,
Did I impress you with Marbury versus Madison?
yeah. So if no one had filed an objection to the second set of nomination papers, would that have been filled?
State the question again. Sorry.
If someone had not filed an objection to the second set of nomination papers, would the vacancy have been filled?
It's a theoretical question that's not an issue here. They were objected to, and they were never valid. The candidate admitted the action was a nullity. So that's not our facts here.
Just
Go ahead.
generally
Yeah.
respond, okay.
Yeah.
So here we go with an additional new arguments. So the first thing that council raises is the Lenahan case, and that every time you see the word primary, you have to substitute it with the word caucus. Where does it say that in the objector's petition? Remember how they have to fully state the nature of the objections? That's a new argument now. But also, that's not what the Lenahan case said. Now, the Lenahan case was challenging in Schaumburg Township, the Democratic Party's attempt to fill a vacancy in nomination at a time when they didn't have a committeeman in place. So when the appellate court went through that analysis, actually, the Lenahan case supports our position. Because they say when a party makes an inadvertent mistake with respect to caucus, you leave the person on the ballot. And the Lenahan case, the appellate court restored the candidate to the ballot that the electoral board took off. But let me tell you specifically what Justice Stoller wrote in that. He said, because he does, note what he does not say. He does not say anytime you see the word primary in a statute, you have to replace it with caucus. It says the caucus is an equivalent of a primary election. So in the absence of fraud or mistake, the nomination of candidates should be given the same level of credence as the results of a primary election. That's a lot different than saying every time you look at the statute and see the word primary, you're just going to substitute. But words are actually important. The other thing that's important is the jurisdiction of the electoral board. You are not legislators. You do not make law. You're a quasi-adjudicative tribunal, and your jurisdiction is limited to what the election code says you can do. And you take up the issue of the validity of nomination papers. So in this instance, the law that you have to construe is section 7-61, and words are important here. Any vacancy in nomination under the provisions of Article 7 occurring on or after the primary, but there was a primary in this instance. And while council argues that you have to construe the township code consistent with the election code, and that's correct, there's nothing in the election code that says it rewrites the there's nothing in the township code that says it rewrites the election code in this instance. So it says if the vacancy occurs on or after the primary was February 26th. There wasn't a vacancy that occurred after that, although arguably now there's a vacancy for the party's failure to nominate at the primary, which they can fill also within 8 days of yesterday when the vote results were satisfied, if we're going to go that result, and prior to the certification of candidates. That didn't happen in this instance. So so the party didn't violate that. All right, and the second part is they have to fill it after, if the vacancy occurred after certification, but prior to 15 days before the election. That's the period we're in now. So the vacancy occurred by the second act of the electoral board on that when the February 14th ruling came down. And to the point asked by Mr. Mullen, had the objection not been filed, the candidate would have been on the ballot, right? I mean, so therefore, if this objection was not filed, the candidate is on the ballot. Why is that? Because he filled the vacancy and nomination, and the procedures for that are outlined in 7-16. So the electoral board doesn't have the power to substitute words in a statute or to rewrite it. Next, the objector argues the party had no authority to fill the vacancy at the time that they did. Again, where do we see that in the objector's petition? We don't. There's nothing in there. Now, it's interesting because he said, well, when you look at the first objector's petition, they argued the party did not have authority to fill the vacancy nomination. That's nowhere in the second objector's petition. So the first time we're hearing that argument is now, coming up now. That just goes to my point about why you need to fully state the nature of the objections. Third, this whole thing about what was agreed to by the previous council related to the previous objection. First, it doesn't really matter in a sense because the electoral board took the candidate off the ballot. That's the act that created the vacancy, regardless of the reasons why. But there was not a stipulation globally that every part of the objector's petition in that instance had merit. So if what they contended was that there were grounds for the objection to have merit, there were two bases argued in that objection. One was that the receipt for the statement of economic interest was not filed with the resolution, again, even though it was already on file. And second, that the vacancy in office was, even though it was filled timely, that the resolution was improper. The email from the candidate's prior counsel doesn't state, well, we agree with both parts of that. They just waved the white flag and said, we're not gonna fight this, just do this. And they filled the vacancy nomination again. So, and there was no agreement in council's email that everything was a nullity. There's been repeated statements that it was admitted to all parties to this action that the prior proceeding was a nullity. There was no stipulation that everything was a nullity. Now, the Maskey case, which again was not argued in the objector's petition, council concedes, well, that was really different issues here because it was on a predecessor section of the statute that imposed a 60-day deadline for filling the vacancy nomination with the primary. And in that case, the party filed on the 61st day. So they couldn't go back and fix the not having met the deadline date. But the first objection in this case it didn't have anything to do with deadlines. It was that he didn't file the proper credentials, which he had at the time. He just, this is the fourth assessor this election cycle that I know of, that filed a different document instead of actually the one that they needed to file. And they also filled the vacancies in nomination, but for whatever reason, there was not a missed deadline. So the first filing wasn't based on a missed deadline. And the second one, part of it arguably could have been a missed deadline, but they actually filed that, they actually filled that vacancy in time. That wasn't what the challenge was. The challenge was that the party voted to fill the vacancy in between the date the electoral board articulated their decision and the date that the final written decision was actually signed. But what that email from the previous council does not admit to is that was a vacancy. He could have, or that was improper. He could have been just saying, well, because the receipt for the statement of economic interest wasn't filed a second time, that's what it was. That email doesn't say that. It just says they're not contesting it. It doesn't say that we concede every possible argument here. So the Maskey case, also not raised in the objector's petition, is also inapplicable. So for those reasons, the act creating the vacancy in this instance was the February 4th ruling of the electoral board. They concede in their objector's petition that the party filled that vacancy on February 17th, which was within the 8 days. So there's nothing they can point to in statute that has been violated in this instance by the candidate. And I mean, that's what the silly thing is, because now if there's a ruling today to take them off the ballot, there's a vacancy in nomination created by the party's failure to nominate at the primary. So they put them back in, or they run them as a write-in. I mean, so this is just going to keep going on and on. But again, when you look at the objections, the arguments that he raised are not in the objections at all, which is why the motion to dismiss should ultimately be granted, even if it's not fully prevailed on the merits. Thank you.
I want to ask you the same question. What does it mean to fill a vacancy? And where do you draw that authority from in the statute or case law?
Well, in 7-61 itself, it says, when there's a vacancy nomination, this is the procedure to fill it. So the performance of those functions under 61 is how the party fills the vacancy.
Okay, so if the party doesn't do those things correctly, is the vacancy filled?
There would have to be a determination that that wasn't done correctly. But if they, in this instance, if the party filled the vacancy by doing the resolution, just like Article 10, Section 10-8 of the election code says, that you presume that nomination papers are valid in the absence of an objection, the presumption would be that those are valid. So there would have
Okay,
to
but
be.
if there is an objection, I guess the question is these nomination papers were filed on, the second set of nomination papers were filed on January 22nd, right?
Yes,
And the candidate was removed on February 14th.
yes,
Okay, so your argument is that the vacancy was filled during the time between when the nomination papers were filed and the time he was removed, correct?
yes.
Okay, and what language of the statute or case law is there to say that that period of time the vacancy was filled?
It would be the satisfaction of the conditions established in 7-61.
Okay, but
Because
there's a
basic-
finding by the electoral board on February 14th that those conditions were not satisfied. So does that go back to January 22nd, or does that mean that if those conditions were not satisfied, was the vacancy actually filled?
Well, there's not any case law that says it relates back and it completely invalidates it. So there's nothing that would say that it wasn't filled back to the first initial date of filing.
Okay, but there's nothing that either party has pointed me to that points either way.
I think Maskey does.
I
Matt,
disagree,
the
but
principles.
I disagree, but all right. Anything else you want to add to that?
Well, I'm not sure.
Can I say something here?
No,
Because
you may not,
I can't, because
because you,
as the party of this, I mean,
You-
you may-
he's one being thrown off, but you guys are going after the Republican Party. That's what it said in your objections here.
Okay, so I
And
am not the objector. I'm the counsel to the electoral board. This is a
Right.
judicial proceeding and you're out of order. And if you continue, I'm gonna have you removed.
That's fine, I might leave soon anyway, but that's okay.
So if you have a candidate that's removed from the ballot, the party fills the vacancy. I don't know, I guess, well, whatever, just not
Okay.
gonna stand the argument.
So
And your reply?
where does it stop? The principle of Maskey is that if you're allowed to do.
Okay, in
I-
Maskey, there was no attempt during the 60 days to fill the vacancy with any nomination papers, correct? Am I correct?
You're correct,
Okay, so continue.
but there was no attempt in this case to do it in compliance with 7-61. That's similar as there was no attempt to do it in compliance with 7-61.
There was an
Maskey.
attempt
Well, there was an attempt in Maskey too.
after the 60
But-
days.
Fundamental principle is you can't interpret these actions in a way that undermines the timeline set forth in 7-61. And if this is allowed to go forward, as she said, it's unending. When's it gonna stop? We don't know, because her argument has completely undermined 7-61, that it's unending. That's not the purpose of the statute. The deadlines have meaning, they have to be given meaning, so that the ballot can be set and a clean and clear election can be held. They didn't meet the deadlines. And again, paragraph 10 of our objectors petition, the January 21st resolution had no effect and was a nullity. The email from council in the order. The grounds stated in objectors petition have merit. She can't collaterally attack that finding. One last issue, as it relates to the statute, 7-61. I apologize, here it is. Any vacancy occurring on or after the primary prior to certification of the candidates, if we accept her interpretation, it has to occurring on or after the primary and prior to certification of candidates. That will never occur. In her argument, the primary occurs February 25th. Right? But it must also be prior to certification of the candidates. That occurred on January 23rd. Her argument creates two conditions that will never meet. So you can fill the vacancy under this sentence the day before the election. It's nonsensical. It's caucus, between the caucus, December 3rd and January 23rd. That's what that sentence applies to. And then afterwards, the second sentence, if it's after certification, has to be filled within 8 days after the event creating the vacancy. For all the reasons we stated, that event was January 21st.
Okay. Do you have any questions for the attorneys? Questions for me?
Does Mr. Welch want us to act like February 14th didn't happen?
So 7-61 says you need to fill the vacancy by doing certain things. And so a vacancy occurred on January 22nd. I think everyone agrees with that. And on the 22nd, later after the vacancy occurred, the candidate refiled nomination papers, and those nomination papers said that he was nominated at a meeting on the 21st and did not include the receipt for a statement of economic interest. Okay, that happened on January 22nd. Then there was an objection filed that said that that set of nomination papers was invalid for two reasons. One, because the meeting nominating him occurred before the vacancy occurred, and that was improper. And the second reason was that he did not file his receipt for statement of economic interest with his nomination papers. Okay, so January 22nd, those nomination papers get filed. February 14th, we remove him from the ballot, right? So the question for you.
For the second time.
So the question for you, I think, on the merits of the objection comes down to whether when Mr. Dorada filed the resolution and the statement of candidacy on January 22nd, whether he filled the vacancy from January 22nd to February 14th, whether during that period of time the vacancy was filled, and then on February 14th, a new vacancy occurred that they filed nomination papers to fill, or whether that period of time from January 22nd to February 14th, even though he filed the nomination papers, because they were invalid, that did not constitute filling the vacancy, right? So I've asked both counsel if they have any case law or statutory authority on what it means to fill the vacancy. And, you know, you heard what they had to say, but there's not, like, if you look at the word vacancy, there's a statute that says a vacancy occurs when someone dies, when, you know, and it lists the things that happen. And so we know what a vacancy is because the statute defines it, but we have to decide as a board what it means to fill the vacancy and whether the nomination papers filed on January 22nd filled the vacancy for the time period before we removed him from the ballot, such that it created a new vacancy on February 14th. And to me, it seems like that's what the case comes down to, and I don't see a lot of, there's no case that I can say to you, this is what the decision is. There's no statute that says this is what needs to be done, right? So this is this is up to your judgment based on their argument. And to me, that's what the merits of the case hinges on.
When we met.
And then the other question is whether what was in the petition was enough for you to understand that that was what the argument was.
That's the objection, the motion to discuss.
Right, so, you all can deliberate in public with each other, someone can make a motion. I would ask that the motion include resolution of the question of whether the objector's petition sufficiently stated the objection and your opinion on the merits of the objection. So you can say it's sufficiently stated, but we're going to deny the objection. You can say it didn't sufficiently state, but we're gonna, deny the objection, however you want to do it. Yes, you make the motion,
Okay, could we not pull a motion for a recess?
10 minutes.
I'd second that.
All in favor, say aye.
Aye.
All right, see you all back in 10 minutes. Do you want to pause the recording for a moment, Bill? Go ahead.
Sorry, guys.
Are you ready? Okay, I'm calling this hearing back to order at 11:40 a.m. We'll start with the roll call. Anita Liskey.
Yeah.
Colin Rockis.
Here.
And Michael Crowner is also present, so we have all members of the electoral board present.
And we're recording.
And we are recording. Yes. Okay, I believe, do you want to get started with questions?
Well, I do have a question, and as we try to figure out these deadlines, and did we miss or not miss, or when was the vacancy or not the vacancy? The question I have is all the way back to the the original electoral board where we voted to sustain the objection on Friday the 17th, but then we didn't meet to sign it until the 22nd. I can't, why didn't we sign it on Friday?
Because I had to write an opinion, because it has to be in writing.
Okay,
And so we recessed and came back and reconvened on the 22nd just to sign the,
but the decision was essentially made on the 17th.
but but
We
it's,
didn't sign it, understood, until the 22nd.
right, so as a legal
Causes the
matter, it's,
question of this 21st.
as a legal matter, the vacancy occurred on the 22nd.
I think the other issue there is, remember, there was changes of votes in the middle of the hearing on that date.
That I don't remember. I'm
Whoever
just
you-
really
you were-
trying to establish, like, we made the decision, but we didn't sign the decision, so is the deadline, like, how improper is the 21st? That's what I'm trying.
Well, we
to
already-
get around.
I think that was already what we settled on the 14th.
We obviously didn't settle, because here we are.
No,
So
that
that's what
specific date.
And that's what I'm
I
getting
hear what
at.
you're saying. I'm just trying to process all of that.
So we never made as an electoral board a decision on they essentially. I sent you the email during the break. Did you see the email?
Oh, I didn't. No.
I sent you the email, so you had the exact language of what he said.
Okay.
But we did not make a finding that. Any particular part of the objection was true or not true. He just said the grounds for the objection have merit and they're not contesting them.
Well, paragraph 5, you said you find that petition states sufficient grounds to remove.
He's not admitting to all the grounds or giving us the full detail. It's up for
You-
debate.
You have,
It's up
you
for
have to
debate.
interpret the language. You
Right.
you have the exact words that he used and.
And right, and I-
You
it
have to
matches,
decide
yeah.
what that means.
I'm just a commoner. It's two vacancies to me. There's a vacancy. They filled it. We threw them off. There's a new vacancy. We fill it. I mean, there's two vacancies, the way I see things. And
2 points of vacancy.
yeah, I mean, I just am having a hard time just making February 14th just completely like a non-event. We did it. We made their case. We took them on. We went through it again. My thoughts.
When you say we went through it again, I mean.
The electoral board. I'm speaking.
The second one.
Yeah, we went through.
Because we were on both.
Sorry, I don't
It's
know.
fair.
Yeah.
I guess a tough part then, because there was no arguments, we weren't. Like, we could have all been approving a different idea of whether we felt the full case or the full objection, or if we were just deciding based on the statement of economic interest, right? And we did not explicitly state which one, we just kind of said that the grounds have merit, which.
Right, yeah, that's what we said.
See, my interpretation of. When we are approving. Or not approving, but is it upholding the objection? Sustaining the objection. Was that we agreed with the petitioner's arguments.
And so the electoral board finds that objector's petition states sufficient grounds to remove candidate Dorada from the April 1 ballot. Says the electoral board finds that objector's petition states sufficient grounds to remove candidate Dorada from the ballot.
Exhibit 5, paragraph 5.
Were you guys clear when you read Margaret's objection? Did you go, this makes total sense? Did you understand why we were being called back to do this?
Yeah, I understood that.
Meaning,
That they
were you
questioning
confused
the
as to
date of
why
the
there was
vacancy.
no February mention?
What do you mean?
Why in Margaret's Tyson's objection, you're going through this, you didn't feel like you were in a time machine? Going, did she not know about February 14th? Like, you felt like, wasn't that confusing to you?
We'll back up.
I mean, it's mentioned in in bullet 12, but like, you're like, wait, why do you keep going back? It just was very confusing to me. The resolution purports to have been adopted on February 17th. Yeah, it was. We created a vacancy on February 14th.
What are you looking, 12?
Mhm. That's the first mention of it.
I don't think it ever says anything that didn't occur on the 14th. I think it's just stating that that action creates a vacancy on.
Well, that's
to
the question,
22nd,
right? We're talking
Yeah.
about deadlines and then says. Blah, blah, has created a vacancy in nomination as of February 14th.
Mhm.
That's in quotes.
But that's, let's see. That's the resolution for the party. That's the party's resolution, not ours, right? That they're referring to in paragraph 12.
Yes,
So,
paragraph 13 or
paragraph 12, the resolution which.
Well, that's the party's
That's, okay,
interpretation.
that's the.
That's the
party.
party's interpretation, not ours,
Okay,
correct?
yes,
So we did not. Because our decision did not state there's a vacancy effective as of X date.
it did not.
And so that's the question in order before us today.
So at some point, someone's gonna have to make a motion. One way or the other.
So we have two motions that or two items to. First is the motion to dismiss and then the merits of the case, correct?
Correct.
So I'm going to move that we, is it dismiss the motion to dismiss? What would be the,
If you either move to grant or deny. the motion.
okay, so I'm gonna move to deny the motion to dismiss. And then we'll make a decision on the whole case after that. So I'm gonna move to deny the motion to dismiss. Can I get a second, please? Okay, hearing none, do we have any other motions on the floor?
I will make a motion to dismiss.
To grant the motion?
Grant the motion to dismiss.
Correct.
Second,
I need a
I'm
second.
seconding
Which one?
hers, the motion. You made a motion,
Motion,
yeah,
To grant the motion to dismiss.
that,
So the motion to dismiss based on insufficient information in the original objection.
objector
Okay,
petition.
are you prepared for a roll call on you?
yes,
Okay, so moving on to roll call, Anita Liskey,
yes.
Colleen Ruckus.
Yes,
Michael Crowner, no.
Okay, so the motion to dismiss is granted by 2-1 vote.
And the second motion, if you can
Is
explain.
no.
Well, I don't know that now that you've made the motion to dismiss that you can do that.
Okay,
So, I think that's it,
okay,
and you can call for public comment and then adjourn.
Thank you.
okay,
Oh, wait, if you. I need more time to do to do the decision, so,
Do you need
I-
to recess to do it here?
yeah, we could recess to do it here and come back after lunch if that. Or we can come back at 12:30.
Whatever works with me, whatever works with you guys.
Does 12:30 work for all of you, or is that too late?
No, it's fine.
I have one other question before we recess. Oh,
well, we still got public comment as well, so we're
Okay.
not fully recessed, but
Got
if
it.
you have any. Other.
no, I'll wait till public comment.
All right, so, I move to recess until 12:30 PM.
Are you doing public comment now or 12:30?
We will do it after that point.
So everybody has to wait around?
Yes,
For public comment?
it'll be after the consideration of the case.
But you can do public comment now because you're in session. You could
Well,
do public comment now while the public is
the
here.
the agenda has the consideration of the case and then.
You could also
public
move
comment.
to change the agenda. Be able to allow public so that the public doesn't have to come back at 12:30. I think that's a misjustice. If you're not gonna allow the public to come in and have comment now. As you just said, they should have the right to, and not have to come back at 12:30 because you have to have extra time to fill out your paperwork.
I think it's a fair point. Is
Motion to
Yep.
change the agenda.
make a
Motion to allow
motion,
for public comment.
and make a motion to allow for public comment now as opposed to 45 40 minutes later.
Second.
Okay, roll call, Anita Liskey,
Yeah.
Colleen Rock, yes, Michael Crowner, yes, on the public comment.
Chuck Mayer, current chairman of the Wheatland Township Republican Organization, former majority leader of the Will County Board. This is a travesty. The fact that I personally came with the economic interest and had Bill stamp it, and I could bring that paper back to you each time. Not just what happened in December, but in January and February, I have stamped documents. So the fact that this even went this far is such BS. It's a misjustice to this man who's been putting his time and effort to just get on a ballot where the Democrats don't even have a candidate. They don't even have the ability to put a local Wheatland Township person on a ballot to run against this guy and trying to take the voters' rights away to elect a delegate or a candidate for their position is a travesty. I am so glad that this board at this juncture saw the problems with this case and went and voted to dismiss. Because this man belongs on the ballot, he will be on the ballot, and he will be our new assessor. So thank you very much for your time. Thank you very much for making a change to your agenda to allow me an opportunity to talk today.
Colleen Ruckus, trustee, resident. I think we had talked about the bills that these taxpayers of Wheatland would incur for these events. You said that you were gonna provide at least 2 of them for the first 2, and it hasn't come through.
No, I was told that it was too late to get it for the March meeting, so
But I
I said I would
still
get it for
requested
the
it.
April.
It's still
I didn't have time to do it. so
Okay, not for tonight. How about a ballpark?
I don't know.
What's your hourly rate?
I think my hourly rate for the township is significantly reduced. I think it's 200 an hour.
Thank you very much. That's all I needed.
What?
Throwing township attorneys under the bus, man.
Any additional public comment before we move on?
Just, I agree about the time that's been spent on this and for what.
All right, we will. Did we already do a roll call for recess or did we? No, we did not.
No.
I moved to recess to 12:30 PM. Can I get a second, please?
Yeah.
Anita Liskey. Roll call, sorry.
Yes, I support that.
Anita Liskey.
Yes.
Colleen Rockets was yes. Michael Crowner, yes. See you all at 12:30. Can you please?
You're fine.
Ready. Recording?
Yep.
Okay, I call this meeting or this hearing back to order. It's now 12:30 PM. I'll do a quick roll call. Anita Liskey,
Here.
Colleen Rockets,
Here.
Michael Crowner is present. Counsel Ed Mullen is present and counsel for the objector and the candidate are also present. So we just have to.
So,
sign
yeah,
the
I
final
make a
document.
motion to adopt the decision and then sign it.
Okay, I move to adopt the decision. Can I get a second, please?
Second that.
Roll call, Anita Liskey,
Yes.
Colleen Rockets.
Yes.
And Michael Crowner, yes. Thank you.
We need to sign 4 copies.
All 4 copies. Okay.
Yeah.
Feel like UN meetings where all the leaders are at the board signing them.
Okay, and would you acknowledge receipt of the opinion for the record?
Yes, thank you.
Ron Morgan for the objector acknowledging receipt.
Give it to.
Wait a minute, though.
Hmm?
Is this right?
What?
Is that supposed to be February 14th?
I'm doing something.
No, the nominated papers were filed on January 22nd. He was kicked off on February 14th. It is correct.
Candidate argued that the objector's petition made no allegations regarding January 22nd.
Nomination papers. The papers were filed on the 22nd and he was removed on the 14th.
Okay.
That's correct.
Okay. I'm just saying, they've made an argument I didn't think I'd like, but okay.
Well, you said that the February 14th decision. But the February 14th decision removed, invalidated the January 22nd petitions.
Okay, gotcha.
So with that, we take a motion to adjourn.
Yes.
Okay, move to adjourn, today's hearing. Can I get a second?
Second that.
All right, well, roll call,
Well,
Ulysses.
you're adjourning the electoral board.
Yes. Adjourning the electoral board, the township officers electoral board of Wheatland Township. Can I get a second, please?
Second that.
All right, roll call, Anita Liskey,
Yes.
Colleen Rock,
Yes.
Michael Crowner, yes. Thank you all. Have a great rest of your day. All right. Hat back on. I can see.
I will see y'all.
Oh, that's right.